Good afternoon, folks. This is the introduction to construction law brought to you by the Continuing Professional Development Committee of the Yukon Law Society. My name is Tom Elliott, and I am your moderator today, with your presenter being David Plunkett. I'd first like to begin by welcoming you all, wherever you may be, Whitehorse, somewhere else in the Yukon, British Columbia, maybe even in Nova Scotia, where I am, wherever you are, welcome. I'd like to acknowledge that I'm in the traditional territory of the Mi'kmaq people here in Nova Scotia. And so I'd like to note that. And I'd also like to welcome you back, or those of you who initially signed up for this presentation for June 28th. We had some technical issues that day that did not allow us to proceed. But I'm glad that if you signed up for that day, that you've returned again. And for those that have joined in, that's great. We have approximately 61 participants today. I have a few housekeeping items for you. First of all, you should have the materials. I believe they've been sent out to you. The PowerPoints are prepared by David Plunkett. I will be monitoring the chat room for questions and put them to David as is appropriate. Please note that this event is being recorded, and as mentioned, questions or comments that you have, do put them in the chat room, and I'll keep an eye on that. I'd like to now turn to introducing our presenter today. You've all received the email announcing this presentation, but let me just give you a few highlights about David, beginning with the fact that he's joining us today from Vancouver, where he is a partner at Burrard Law, which is a Vancouver law firm. David's practice focuses largely on construction and real estate related matters, and that'll be very clear to you as he presents, and perhaps obvious from his PowerPoint presentation. David is both a member of the BC and Yukon Bar. He's also a very active Canadian Bar Association member. He's been on the National Executive Committee of the National Construction Law section of the Bar Association. He's also, as chair, he's also been chair, now past chair, but he's also been chair of the BC Construction Law section of the Canadian Bar Association. So I think with that, I'll turn to David to take it away. The floor is yours, David.
Thank you, Tom, for the kind words there. So welcome, everybody. Thank you for sharing your lunch hour with us for this very enticing webinar, I'm sure. So at first, I'd like to say, I'm very passionate actually about construction law. I think it's one of the better areas to practice in. I've been practicing in this area for longer than I want to admit, and between the different areas of law and the different factual matrices and the parties, it's never a boring area to practice in. So that being said, I've got a lot of material to cover here today, and some of it this is intended to be an introduction. So some of it will be very basic. I will try to delve in to some more nuances as well to try to appeal to as many in the crowd as we can. But that being said, it's just myself who will be droning on through all this material. So I encourage you to ask questions. I can hopefully think on my feet and switch gears as we go. I'll allow Tom to do all the moderation on that, moderating on that, and I'll let him know if he wants to pose a question. So just put them in the chat, and that way we can have more of a dynamic discussion here today. So, and I apologize that we weren't able to do it on June the 28th. There was a technical issue, but here we are. So let's get into it. So what I propose to cover today are these 4 topics. I'm going to go over standard form agreements, drafting construction contracts, essential terms and common pitfalls, risk allocation clauses. We'll take a look at that if we have time, and then I'll give a high-level overview of construction insurance and bonding products. So let's talk about standard form agreements. So in construction, we like to have, because there's so much going on and things can become so complicated, rather than redrafting a contract for every single project, we will use what we call a standard form. So these are 4 different categories. There's many more than this. And what this means is that when we use what we call a CCDC contract, and we'll get into the different forms of that, such as a CCDC2, we have a standard form of all the provisions of that contract, and it's a sort of a plug-and-play contract that can be used on various different construction projects. So as you develop as a construction lawyer, it's important you'll get to know these very well, and you'll understand all of the standard forms. And so you'll be able to cite, for example, CCDC2, delay claim provisions and so forth off the top of your head, because they are standard and they're used from time and time again. So I've just named 4 that I think might be relevant to the audience here. The first is CCDC, the Canadian Construction Documents Committee. That's a committee from across Canada, as architects, engineers, lawyers, and so forth. And they draft a series of different forms of construction contracts for different scenarios. This is probably the most widely used standard form of agreement, particularly in the commercial venue, such as building buildings and so forth. And they are also incorporated even into other more complicated bespoke agreements that some of it's used, or subcontracts are used in those as well. So CCDC is the most important, and we'll spend probably all of our time here today on CCDC. MMCD is the Master Municipal Construction Documents. So definitely in British Columbia, if you are ever going to do any work on a municipal project, they're going to use MMCD. I've looked into the Yukon. They haven't incorporated this yet, but other provinces are looking at that. And again, they all have the exact same standard wording, but the MMCD also has standard form specifications. So for example, all of the plumbing specifications, mechanical, electrical, are all based on a standard form of MMCD, which of course can be changed. The third is the Ministry of Transportation and Infrastructure. So this is the federal Canadian government have for any highway type project, or overpasses and so forth. They will use their own standard form agreement as well. It is, in my view, somewhat one-sided to the Ministry of Transportation and Infrastructure. So it is something that's very important to understand if you're dealing in this area. I know in the Yukon, with the Alaska Highway, I've had cases dealing with projects along that highway, and they often don't use this because of the American counterpart that does provide funding, and so they sometimes use their own bespoke agreement for that. But most of any type of highway type, which is quite a bit, will use Ministry of Transportation and Infrastructure. Then you have the Yukon Territorial Government, their procurement department. They have their own standard form agreements for procurement in a variety of different ways. And for example, for hospitals and schools, I've seen that I've had cases in the Yukon on those. They use their own in-house formulated standard form for those as well. So let's get into, I'm going to talk about CCDC primarily, and this is going to help us for those of you who aren't as familiar with construction projects to sort of understand the factual matrix of how we set up a project, how the players on a construction project, the role between them, because there's a various different ways that it can be done. And one theme you're going to hear me speak about repeatedly today is allocation of risk. And I just want to say from the outset that, risk is not a bad thing, okay? Construction is, in construction, you're in the business of risk. And every construction project is highly risky. There's so many variables. Nothing is going to go as the way you think it's going to go. So there's a risk involved, and a contract, in my view, the primary purpose of the contract is to allocate risk between the parties. And as I said, there's nothing wrong with having risk, because you have to take risk on. The problem is when you don't understand the risk that you're taking on, because when you're advising a client, you have to make sure that they understand the risk and they're pricing the risk. So if I'm an owner and I have a contract that's completely one-sided, that is fine, but they ought to pay for that, because they're buying the risk from the general contractor. They're saying, well, we don't want risk, so you better pay, you better price that into your price. Otherwise, you're going to run into problems. When you have a problem on a construction project, I mean, the ultimate goal or objective of your client is to remain in the black and not lose money on the project. They want to make money. So if they have a bigger buffer because there's a risk and something happens and that risk does manifest itself, they have a bigger buffer. So everything I'm talking about today, you have to think about it in terms of the allocation of risk. And so these are, I'm going to go through these, but these four types of contract are basically allocation of risk contracts. So a CCDC2 is a fixed price. That's where, I'll show you the breakdown of the parties. But that's where, I go to a general contractor, build my building. How much is it going to cost? Here's my drawings. They say $5 million. That's the price. Of course, there's going to be changes and so forth, but it's a fixed price. Cost plus, I go to my general contractor and I'll see the relationship. I'll pay for the cost to build it, plus a fee that I'm going to charge or be charged by my general contractor. Construction management is a little bit different. I'm going to get into that as I go through the slides. And then, of course, there's design build, which is another allocation of risk situation. So let's go through these a little bit. So the first is your, what I've done here is I'm trying to show you some of the contractual matrix or the roles of the parties, so you can understand that. And I'm going to point to which contracts apply in each situation. So the first is where an owner has one contract with the general contractor. So I'm hiring them to build it. Under the CCDC regime, we're going to have, that would be either a CCDC2, a fixed price, or a CCDC3, which is a cost plus. So the point here is the general contractor has all of its individual contracts with the subcontractors. And that is what we would use if we're using the CCDC regime. It's a CCA1, it's a stipulated price contract. That's the typical one we'd use for our subcontracts. Then if the subcontractors use material suppliers or subcontractors, that's where we often see purchase orders and sort of different types of contracts that don't fall within the CCDC. One thing I'm just going to quickly point out here is if you look at the line between the owner and the architect, and then there's a line between the architect and the general contractor. So This is one of the interesting things about construction law is that it's not your basic contract law, because you have parties that aren't parties to the contract that play a role within that contract. So in a CCDC, they're going to refer to the architect or the consultant, and the consultant has certain roles, and they're significant. For example, they will typically be the payment certifier. So every month when the general contractor issues a progress claim, the consultant has the responsibility and has the power to determine if that is the accurate amount to be paid or not. If there's any dispute in the contract, they're effectively an arbitrator of first instance. So example, if you have a change order or something, they will determine if there should be an additional cost or to the owner that has to pay the general contractor. So the problem with this situation that we find is that, generally speaking, when a general contractor has an issue and it involves additional money that they're asking for, it's an issue related to design. So they say, well, the design did not contemplate these extra costs, or the design wasn't properly coordinated, and now we have to make changes, and I want an extra fee. And the owner says, well, you should have known that. It's the architect who actually did the design, who is there then interpreting whether or not it should be paid by the owner, or it's a cost that should be consumed by the general contractor. So there's always a conflict there. It's always an issue we deal with all the time, and it's not a perfect system, frankly. And I have my own thoughts about how to deal with that, but we'll deal with that in another presentation. So yeah, so the only thing is you see, you're going to see different types of contracts the lower you go down the contractual chains, and you sometimes just see a purchase order with a few conditions. It's not as significant of a contract as the other ones that we've looked at. So the next general form of how we could set up how to build a project is what we call construction management. And this is where the owner will have contracts directly with the trade. So now we don't have a general contractor, we have a general manager, and that general manager is kind of like a consultant. They have responsibilities like we would as lawyers to our client. They are truly a manager. They're managing the project. Often the trades are all their trades that they bring forward. Often they sign through, it's kind of a funny situation because they sign on behalf of the owner through agency type arrangements. But the reality is the owner is now taking on more risk, because not only are they paying, so in this case, they would pay all of the costs, like a cost plus contract, and then they pay a fee to the construction manager, but they also have a direct contract with the trade. So if a trade goes bankrupt or there's an issue with that particular trade, the owner takes on the risk for that one. Okay, so we have those can be either under the CCDC regime. The true construction management would be a CCDC 5A, and within that contract, there's going to be a bunch of responsibilities that the construction manager has. For example, scheduling, coordination of trades, providing updated budgets, updated reports, and so forth and so forth. So there's a very specific list of responsibilities that they have. A CCDC 5B is an interesting vehicle. So the intention of the 5B was to be a convertible contract. So it's intended to start out as a 5A, just as we see here with this type of contractual matrix. But at a later date, once all the pricing is confirmed, there's an option to convert it into a CCDC 2 or a CCDC 3, or to have a guaranteed maximum price where the construction manager says, no matter what, your project will not cost more than $5 million. So the reason why the CCDC committee put this together is there's a lot of time on construction projects like a CCDC 2 or even a CCDC 3. you really need to have all of your drawings and specifications prepared right from the outset. In reality, in construction, that often doesn't happen. There can be a variety of reasons for that. It could be a government who all of a sudden got some funding, and if they don't spend it within their particular year, they're going to lose the funding. So they have to get started with the project. They don't have complete drawings. They might have enough to do, foundation work and excavation. So they want to get the project started, but they're not ready to get a fixed price. And so you would have like a CCDC 5B with the intention of completing it later. In reality, it's very difficult to convert it because nobody ever agrees on the price. The construction manager likes the flexibility of not taking on the risk. So often it never really actually works. So the 5B, in my view, hasn't worked as well as it ought to have. So then you might ask yourself, so I've explained a scenario as to why you would have a 5B. So why would an owner ever want a 5A? So there are good reasons for a 5A. For example, if you're building a custom-built home, construction management is a very good agreement, because this is something where you're going to be making decisions throughout as you go. There's going to be lots of changes. You don't know what all the pricing is going to be. And rather than having a burdensome mechanism where you're doing change orders and submitting all this stuff, it's often easier just to do it through construction management. And I typically would recommend that in those situations. And also the owners sometimes want to have contracts with their own trades when they're, sometimes they're outsourcing, landscaping and other kind of work on their own. There's sometimes an advantage to doing that. So there are good reasons for why you would do these different types of situations.
David, it's Tom Elliott here. Just before you leave construction management, I just ask, are there, how would you characterize, sort of in summary then, how would you characterize the pros and cons of construction management approach as opposed to the other approaches?
The pros and cons, well, it depends on which party you are, of course. The pros for construction manager, obviously, is that there is, they're taking on less risk. But, the cons to them is they can't build in as much profit as you might into a CCDC2. From the perspective of an owner, the cons are you're taking on more risk, specifically because you have a contract with a trade. If something goes wrong with that trade, if that trade's not performing, you can't really blame you can blame the construction manager, but it's hard to. Often, despite this situation, I have people coming in and saying the construction manager is responsible for everything that went wrong on this project. And I come back and say, no, look at the contract. There is a provision in there that says that in the CCDC 5A, if the construction manager is effectively, doesn't use these words, but it's the same as negligent and due to their own negligence has increased costs on the project, then you can sue them for those additional costs. So the advantage, I guess, the owner is the flexibility. It's much more flexible. And like I said, if you were doing, for example, a custom-built home, or you have a situation where you don't have complete drawings, but you need to get the project going, those are types of examples where I would say it makes sense.
Thank you.
The next, and there's more than just these scenarios, but these are the basic ones, is what we call a design build. Now, this is where, as we saw before, there would be an architect who designs it, and then the general contractor builds it in accordance with the design. And if there's a problem with the design, the owner is effectively responsible for those additional costs. Because the general contractor bid on the project based on those designs. Okay, so in a design build situation, this is where the owner says, okay, not only are you going to build it, but you're going to design it as well. So you're trying to get the proponent, the builder, to take on all of the risk. You see this in all the PP3 like the really big stuff. You see this a lot, but you're seeing it in other projects as well. And often the design build proponent will be like a joint venture or some other sort of GP between a consulting engineering or architectural firm and a general contractor, and sometimes even the specialized trades become partners in that. So on the face of it, this would be, you would say, is the least risky for the owner in terms of cost certainty. However, it's not free of any risk because the design builder in these situations has complete control over its means, methods, and what it produces. So long as it fulfills the parameters that the owner had provided at the outset, the design builder can do whatever it wants in order to get there. So an example is in Vancouver, for example, when back when we were having the Olympics, we built a big subway to the airport from downtown. It was a design build and up a very important street called Canby Street, a commercial street. They did what you call a cut and cover, where you trench down from the top as opposed to tunneling below. The government said, well, no, we don't want you to disrupt all of our traffic. And they said, well, tough. We bid our project on the basis that we were going to do this. We followed all your parameters. You can't tell us how to build this. And so you've lost that control over that process. I mean, you could make the change, but it would be an enormous additional cost and you would lose the cost certainty. So I see design builds in a smaller context. I always tell the owner, it's a good thing, but you have to be careful and you have to be very clear about your parameters and setting out exactly what it is you want in the end as end product. And if there's any sort of means that you expect that they're going to follow or methodology, you need to set that out in your original parameter. Okay, so that's my that finalizes my the portion on going over standard form agreements. The intention here is to explain the different forms of CCDC, explain a little bit about standard forms, and explain the different ways, the roles that you can have on a construction project. Any more questions before I go to the next section, Tom?
No, we don't have any questions for you yet, David, but all participants, I invite questions. I'm keeping an eagle eye on that chapter.
If there's any, we can always come back to this later. That would be fine. Okay, so now, if you can bear with me for some of the dry stuff, but it's important. I want to go through construction contracts. So whether you're a solicitor or a litigator or anybody else, you have to understand how to read a construction contract. So what I put in this slide here is just sort of breaking down the categories. I may call them the different chapters of the book. They deal with different components of the obligations of the parties. The first is the articles. This is the first part. So when you're trying to identify the parties, the consultants, the price, where the project is, all the basic information, and sometimes you need to get that really quickly. If you're doing a lien or something else, that's in the articles component of the contract. This is a generalization, but this is mostly what you see in these types of contracts. Then you'll see a section that's referred to typically as general conditions. That's the, excuse me, I need some more water. So the general conditions are sort of the meat and bones. This is where the lawyers sort of really get excited. This is all of the specific legal terms dealing with how the function of the parties, how things happen. So this is where you're going to go and look for how to terminate the contract. If you have a delay, if you have change orders, that sort of stuff, those will be in the general conditions. That's primarily what you're going to focus on as the lawyer. The next, which is extremely important, is what we call supplemental conditions. So as I said before, we have these standard form agreements and they have their standard form general conditions. But typically, parties like to make certain changes to those for their own purposes. And those are called supplemental conditions. So you have to then look at the general conditions, then look at the supplementals, see how they've been modified. And you're going to have to go back and forth and refer them back and forth and see what's happened. And typically, certain clients will have their own set of supplemental conditions that they use on every project. If you're asked, to help a client, this is typically what you're looking at. Someone has provided a bunch of supplemental conditions they're not aware of. They want to get your supplemental conditions, and you're kind of negotiating how to modify the contract. I personally don't have one set of supplemental conditions that I recommend for each client. I like to tailor it for each client, but certainly each client will have their own situations that arise in their particular industry, and I will draft their supplemental conditions for those situations. I can give you an example. One that I often, as a general contractor, I'd like to put in is allow a general contractor to charge for a deposit funds. The CCDC regime does not typically, most contracts don't allow you to charge or submit a progress claim for work until the product is actually being implemented into the property or the building or the bridge or whatever it's going to be. And then in some cases you might have like a very complicated piece of HVAC equipment that's being built off site, and you're spending hundreds of thousands of dollars on that, and you're out of pocket, but you can't charge the client. So I'll modify that to allow me to charge the client through the progress claims for that. That would be a typical one that I would use. The other components are, this becomes a lot about the client, the specifications. So that's a big set of documents that explains how to build the building. And so the important thing to understand for that is if you're acting for a trade, they and their subcontractor are going to refer to the specific specification that applies to them. So then you refer to the specification. It might be mechanical 9800. You go to that part of the specification, and that sets out their scope of work. And that's what you look at to see if there's a dispute as to something should be included or not. That's what you're looking at. Then you have the drawings. Obviously important, but they are actually part of they're typically listed as part of the actual contract, because if it says it in the drawings, you're entitled to rely on those. There's also details, which are very specific stuff within the drawings. And if there is a conflict between drawing specifications and details, there's different ways you can apply the hierarchy. Typically, I would say it's details first, then specifications, then drawings. So that's something you often have to interpret when you're dealing with scope of work issues. Schedule is always important. Usually you'll have a schedule attached to the contract. However, that schedule is, you can usually chuck it out the door because no one applies with their first schedule. And most contracts gives the general contractor the right to modify the schedule as they go. But it's important because it might show how much time that particular trade was allocated to do the work, and it may become important later. Rates, this is something I always require in my contracts for my clients. Even if it's a fixed price contract, there may be a time when there's extra and the general contractor is using his own forces to do work. Rather than have a debate later on, I'd like to set out what a carpenter will charge, what rate a superintendent, a carpenter, a laborer, and so forth. That's how much you can charge your client for. It's better to have that set out up front. Incorporation by reference. This is another important thing to understand in construction. Construction contracts are different than normal contracts. You can have a contract with a trade, and you can say all dispute resolution will be So I'm a general contractor. I have a CCA 1 with my mechanical trade, and I can say, or my own contractor, I can say, all dispute resolution will be dealt with in accordance with the terms of the prime contract. So the contract general contractor has with the owner. So you can reference other contracts that become incorporated into this contract, which is obviously fraught with potential difficulties. But the important thing is you have to understand if it's referenced in the contract, you need to be able to look at that prime contract as well to advise a client. So you may need to look at more than one contract in order to and a bunch of different things in order to properly advise your client. Some common drafting pitfalls. This is drafting, but even as a litigator, this is good, important to understand. Obviously, a lack of a written contract. This seems pretty obvious, but it's funny how many times I see pretty big contracts being done without any written contract. There's a couple of emails, maybe, if you're lucky. And it becomes a very difficult. Ambiguity in key commercial terms, that's pretty obvious. Conflicts in contractual provisions. This is something that happens particularly in a supplemental condition. So you'll have a standard form agreement, then you'll take a supplemental and you'll say, well, I don't like this particular provision number 27, I'm going to modify that. But they haven't considered how that is affecting another part of the contract. And now all of a sudden you have a conflict in your contract. So that's something you got to look out for when you're doing a supplemental, for example. Incomplete or undefinable specifications, reference documents. So often the specifications won't be clear on how to build the building, or they'll be the drawings might not be coordinated, so there's a conflict. That's another area that you got to look at. We've already referenced incorporation by reference provisions. Those, I'm not going to go into the law on that, but that they are, there's a lot of problems, obviously, as you can imagine, when you're trying to incorporate other terms from another contract into your existing contract. The last one I have here is compliance with builder's lien legislation. The law is you cannot contract out of builder's lien legislation. Anything that tries to do so will not work. I'll try not to spend too much time on this we have a lot of other stuff to cover. I've just listed out all of the key terms that I think are very important. Obviously, pricing, scope of work we've talked about. Schedule is always important. You always have to look at and what the consequence of delay is. And when I say that, that is because in certain situations, you might be permitted to delay, and you might be your schedule might be extended by a month, but you might not be entitled to your additional costs for that delay. And there's other types of delays where you are entitled to additional costs. For example, weather, you have weather that's holding you up, something that happens in the Yukon a lot. You may not actually be, even though you're now paying, you have a burn rate of thousands of dollars a day, you may not be able to recoup that, although you won't be penalized for the 1 month delay or whatever you have. Changes in the work is always an issue. Dispute resolution, you always have to look at this, the dispute resolution mechanism. It's usually formulaic. You have to usually negotiate with the other side, then you can go to a mediator, and then often it's arbitration. Default and termination, I'll just speak to this quickly. This is something I see a lot of. In most construction contracts, you can't just walk away from the project. You can't, I have a trade that says, I'm just going to walk away. They're not paying me. We have all these disputes over extras. And I say, well, you can't just walk away, because that would be considered a fundamental breach. And you could be on the hook for all sorts of consequential losses. And so you typically, in a contract, you'll have a default provision that says, if the other party is in default, you give them in some instances, it's 5 days. Some it's 3 days to correct the default. And then if they don't correct the default, then you can either suspend the work or terminate. So you have to be careful. Don't let your clients just walk off a job or for even if they're not being paid until you've looked at these provisions in the contract. Indemnities I'll talk about in a bit, but it's very important whenever I see the word indemnity. I'm always looking at that in a contract. Very important. Any limitation of liability, obviously you want to look at that. Insurance requirements, whenever I see a section on insurance requirements or a change in that, I always tell the client to send it to their insurance broker, make sure that they can get the insurance, that there's nothing in there that's going to be offside. Warranties is another sort of a red flag. Whenever I see a warranty or a modification to a warranty, I'm paying close attention to that, and I'll explain that a little bit in a moment. Entire agreement clauses are also very important because what I see a lot of is, say I have a flooring trade, and they say, okay, I'll put in all the flooring for, $200,000, but if if the flooring's not level and you need me to do any work to the floor, that's going to be an extra. That's not included in my price. And they issue a purchase order. Then the other side says, okay, that's great. And then they draft a contract, and maybe it's a CCDC contract. And then they put an entire agreement clause in there and says, well, everything is contained within this contract. And you go back to the specification that's referenced says the trade contractor is responsible for all floor prep. And all of a sudden you have this issue because you have an entire agreement clause. It doesn't mean you can't get around it in certain circumstances, but you got to be very careful there. And that's where I see a lot of issues arise.
David, Tom Elliott here, as you're taking a breath, here's a question for you. In the context of the construction contract, the question is this, that in a world where there is supply chain issues, ever increasing inflation, limitations in industry capacity, and labor market challenges, how does one mitigate those? Can you mitigate those in the context of the contract?
Yeah, that's a very good question. There's a million ways I can answer that, and there's different ways that happens. So that's something I was asked a lot in the last couple of years. For example, let's use a trade example again. They're getting pricing from their manufacturer who says, they can only guarantee the price for a month. The project might not be that they're, bidding or a proponent on with a bigger group, the general contractor. The project might not start for another year. They have no idea what the price is going to be. So one thing, so what do you do in those circumstances? You can have, this might be an example where you would go to, for example, a CCDC 5A, because you don't know what your price is going to be. You could say that you could turn it into a cost plus contract and say you're going to be responsible for the material cost and you're going to pay me my fee or my labor rates to do that. You can say if you want to guarantee the price of this material, or you're going to, I can order it now and I will warehouse it for you, and then I will charge you a cost for warehousing it. So those are a lot of the things that happen. In terms of labor, obviously labor goes up as well. This is where we get into delay claims. So sometimes if a project has been delayed and it was reasonable that the parties understood that the project would start, in 2021, in the spring of 2021, but it didn't start until, for whatever reason, until the spring of 2023. Well, then obviously you have a legitimate basis to say, well, that delay increased my costs and I'm entitled to renegotiate my price. So those are the types of things those are a few of the ways I've seen it, but it's a pretty infinite topic that we deal with all the time. Does that answer the question, Tom?
Yes, but there's a corollary question. That is that It appears that Canada is on the edge of a construction boom as the housing crisis across the country, British Columbia, Yukon, everywhere,
Yeah.
continues unabated, and governments making promises to build thousands and it seems millions of new homes and other construction projects in the coming years. Is there enough capacity in the construction law sector of the legal community? Or do you have a lineup at your office? Sorry, I can't see you for 3 months.
Well, I was going to say, I thought the question was going to be, is there the capacity in the construction industry for that? But I didn't anticipate you were going to say in the legal. The reality is that, yeah, I'm very busy, and but I've been practicing in this area for probably 20 years, and I've never not been busy. So it is a great practice to be in. I anticipate it will continue to be strong. It's strong in every, you're right, whomever asked the question, there's a big push for rental housing. So that's what we're seeing a lot of the construction industry right now. But it's just so funny because as the economy changes, there's just different segments of the construction industry is huge. It's so big, and there's so many different segments to it. So when the economy is doing well, they're building condos. When the economy goes down, there's infrastructure spending, and then so the commercial builders aren't building, but now all my clients that build bridges and roads, they're busy because there's infrastructure spending, and then there's the schools are building, and there's the hospitals that they start building, and so in every segment you see there's always going to be a turn. So the rental housing issue right now that you're seeing the push for, this is just where I'm seeing a transition from the commercial sort of strata construction boom to rental housing boom, and CMHC is a big proponent behind that. But yes, I don't think there'll ever be a shortage of lawyers, and lawyers are similar to construction people, are very adaptable, and they'll change, and they'll learn areas that they think they'll be successful in. So I think that we will be able to adapt and fulfill that need, but I do think that there will always be a need for construction lawyers, and it is relatively specialized because you need to know all of the things we're talking about here, but you also have to have a practical side to you to move these projects forward and not just be a trial lawyer and trying to make a big legal statement over every case. So you have to be able to do kind of both. But anyway, I do think I encourage any younger people in this who are considering this area of practice to pursue it. Did I answer that, Tom?
Yes, thank you.
Bit of a ramble, but yeah. Okay, so how are we doing for time here? Okay, so allocation of risk clauses. Again, this is I won't repeat my little 2 cents on pricing risk, but I'll say it again. Nothing wrong with risk. We're in the business of buying and selling risk, as long as you understand the risk and you price the risk appropriately. So these are just as I've said before, every component of a construction contract has some component of an allocation of risk, even the way that you set up a contract. But these are 3 areas that I just ask that people pay particular attention to when they are reviewing a contract, or in the litigation process. You should be looking at this very carefully, and you'll see through an example of a trial I was involved in why that is. So first of all, guarantees and warranties. What is a warranty? Warranty is a promise to bear the risk of loss that will flow from a failure of a fact to occur in the future. That's a lot of legalese, but basically you're promising that if something happens in the future, you will bear the risk for that. And it's very clearly set out in a contractual term as to how that applies. A guarantee is technically an accessory contract. We might have a guarantee within a contract, but it could be a third party who promises to undertake the risk of a default, or particularly of a third party or of a debt, etc. So a warranty. So we deal with a lot in warranties in construction. You can obviously have an explicit wording in a contract. But there also are implied warranties. You can have, there's various statutes that have warranties included in them. A warranty can be implied just based on common industry practice. So that becomes, a question of expert evidence. The conduct of the parties could result in a warranty if someone, the way that they conduct it, and they provide assurances that something will work. That can be implied as a warranty. And then there are cases on a reliance on a contractor's specialized skills. That can be an owner who says, I don't know anything, I'm just relying on you to build this. And, the courts have looked at that and said, given the nature of the relationship, they relied on the contractor's specialized skills, and there was an implicit warranty of fitness, which is like that the thing would work. That also applies quite a bit when you have a specialized trade, like a very specialized trade. We can say, well, you ought to have known certain things and you did warrant this work, given your representations about your skills. But this is the case I want to talk about to sort of highlight the importance of this. It was a case I was involved in, and unfortunately lost a trial that we were successful at the Court of Appeal. And just to give you a bit of background, so I was acting for the Greater Vancouver Water District, and they had procured they were building these really big water pipes that go into the ground, and these are like massive. You can walk through them, to service the water needs of the residents, etc. And on the outside of these pipes, there was this coal enamel tar coating, which was there to protect the pipes from erosion and so forth, because obviously, you're putting these pipes in for 50 to 100 years. You expect them to last without corroding, etc. So they had contracted out to build these pipes by North American Pipe and Steel, who in turn had them supplied from Korea. And when the pipes arrived in Vancouver, the coating that I mentioned before on the outside delaminated. It all fell off, and so that was obviously a problem. And so they had to take all the coating off and replace it at a considerable expense. So the issue became, what caused this coating to delaminate? And we argued that it was workmanship. And the other side argued, well, no, this wasn't workmanship. This was because of the design that the Greater Vancouver Water District supplied. The specific design that you gave was what caused this to delaminate. And so at the end of the day, the trial judge did find, it was not what I think should have happened, but in any event, you don't win everything. They found that the cause of the delamination was actually the Greater Vancouver Water District's design. However, this was our secondary argument at trial that wasn't successful, but succeeded at the Court of Appeal. And if within their contract that they had, it had these two provisions. So if you spend a moment looking at these, this will explain what I'm talking about. So the supply contractor warrants that the goods will conform to all applicable specifications. That's fine. And then unless otherwise specifies, will be fit for the purpose for which they are to be used. So that's important. They're fit for the purpose for which they are to be used. And then the other provision we relied on was the next one, The supply contract warrants and guarantees that the goods are free from all defects arising at any time from faulty design in any part of the goods. So here, the Court of Appeal said on a plain reading of this language, the supply contractor, the Korean manufacturer, agreed to take on the risk even from the design. So even though the other side's providing the design, I've agreed to accept the risk. And you can't interpret the contract in any other way, and therefore they were responsible. So I can guarantee you, whomever signed this contract when they were agreeing to supply this pipe, didn't look at this particular provision and didn't realize that they were taking the risk for everything on this particular pipe. So this is why I say, whenever you look at a word that says warranty, guarantee, and indemnification, you got to pay very particular attention to it, because this would be fine if they knew about it and they would have added an additional price, or they would have done more due diligence into the design, for example. In any event, so that's and we were successful at the Court of Appeal. This is just the decision that we relied on that had similar language that persuaded the Court of Appeal. It's a Supreme Court of Canada decision. I just put it up there for you guys. Okay, so indemnity clauses. I'll go through this. Is another reason why you have to pay particular attention to these. Indemnity clauses. I'll try not to spend too much time on it, but an indemnity clause is very significant. It's even more than a warranty. It's saying, I will hold you whole. I will make you whole for anything happens that I'm agreeing to indemnify you for. And most contracts have indemnity clauses for third-party liability claims. So, for example, if I'm the general contractor or I'm a trade and I get sued for something that was caused by your negligence, the other contractual party's negligence, I can now sue you for indemnification. So you make me whole if it's caused by your negligence. And it's if it's caused by your negligence, which is the important part. So I don't have a problem with those provisions in the contract. That's pretty typical anyway. But it's nice to have a contractual term that you can rely on if you're making a third-party claim, and you can get your solicitor costs and so forth. But what I have a problem with is when people start to modify these and don't put for your own negligence, for example, and people don't realize how much risk they're taking on when they modify these terms. So if you're ever looking at a supplemental agreement that modifies this, pay close attention. Or if you're in litigation, you're looking at third-party claims, maybe you take a look and see what they put in there. Maybe they've put a supplemental that gives you a lot of ammunition in a case for a third-party claim, and they probably didn't realize it, but I see it happen frequently. Okay, I'm going to move on to the next section of construction insurance, unless there's any other questions about.
David, there isn't any other questions, but just so the audience is aware, we're now almost at the top of the hour. This webinar is scheduled to end in about 30 minutes, and it will. And about 25 minutes after the hour, we'll go to any sort of questions, any final questions or comments people will have, and then with some concluding remarks. So back to you, David.
Well, I'm hoping I'll wrap it up before to leave more time for questions if there are any. But you know, as a litigation lawyer, I'm not always the best at estimating my time, just as in the trial and in the court. But okay, so let's talk about. I'm going to talk about construction insurance, and I'm going to give an overview of construction bonding. These are important things to understand. These would be what I would call the 5 most common. You know, there's so many different forms of insurance. We're never gonna. You might tell me there's something else, but these are the most common forms of insurance that you're going to deal with in the construction context. The first is builder's risk, often called course of construction insurance, all risk insurance, all sorts of things. I'll talk about that a bit more in a moment. Second, commercial, CGL, commercial and contractual general liability insurance. That's typically for when you get sued. Errors and omissions insurance is for architects, wrap-up insurance, commercial vehicle insurance. I'll go through these all on a very, very high level. So builder's risk course of construction insurance, it's what we call a property-based policy. So as opposed to a third-party policy. So what that means is that it's similar to your home insurance. If you insure your home, or you can insure your car, although car is also third-party liability. But you insure your home, so if your home is struck by lightning and it burns to the ground, you have insurance and your home is protected. A course of construction or builder's risk insurance insures the project. So if the project burns down, it covers that loss up to the amount that's agreed to in the policy. If something freezes overnight, the pipes freeze, and there's a massive flood causing damage to the construction project, that would be an example I've seen where you use your course of construction insurance, and it's property based. So often we name unnamed insureds are included in that. So even if it was another party who suffered some loss, they can have coverage as well. It can involve a bar to subrogation. So for those of you in the insurance world, you'll be familiar with subrogation. That's where when an insurance company pays out on a claim, it then steps into the shoes of the party to whom it paid it out and then starts suing other parties. And if you read the decision Commonwealth, it says that you can't do that unless you specifically allow for it in your insurance policy, because it's intended to be a first party policy. It's not intended to point the finger. It's intended to just protect the property. And that comes up in my practice from time to time, because I might have a client that says, well, why do these guys want to sue in my name? Now I got to sue one of my trades that I work with all the time. It's not me suing, it's the insurance company. And then sometimes I have to have the discussion with the insurance company and say, well, you can't actually do that. But you got to be careful, because they're trying to modify their agreements to permit them to do that now as well. Commercial and contractual general liability insurance. So each party will have their own CGL. So this is basically a policy that protects you from third-party claims. It's typically like a negligence claim. This is something I want to spend a moment on because this becomes important when you're drafting your pleadings. Third-party insurance is triggered when there is what we call resultant damage. And it does not cover poor workmanship, which ought to be covered by warranty. So for example, if you have windows that have water that are leaking into your building, that does not trigger resultant damage. It's not really negligence, because you haven't had any damage yet. It would be what we would call, the insurance company say, well, that's a workmanship issue, and that's true. So the fact that the windows are leaking is the problem of either the window installer or the manufacturer or whomever, and you should sue them in contract to replace the windows. However, if as a result of the windows leaking, water now seeps into the wall system and causes damage to the wall system and the insulation and drywall or whatever else it might cause damage to, as a result of the poor workmanship, you've now caused damage. So now you've completed, as we'll recall, negligence requires one of the material elements is damage. Now you have, and I use the words resultant damage in my pleadings. That is what the insurance company is looking for when they're assessing whether or not they're going to cover a claim. And remember, as long as the insurance company has to assume that the facts in the pleadings will be borne out. So when you plead it, if you're looking, sometimes you don't want the insurance involved in a dispute, and sometimes you do, particularly if you think that there's going to be an enforceability issue in your judgment. You have to think about pleading the words resultant damage to get that coverage. Errors and omissions, this is for architects and engineers. This is your typical, professional liability. That's what we have as well, type insurance. Wrap-up insurance, I don't myself deal with this as much. It's intended, a wrap-up insurance is still, it covers the whole project, but it does cover liability claims. It's intended to cover all contractors, professional and trades. Like one event will be one claim on a policy. So for example, if you have, I'm going to just explain the time and risk and substantial performance all in one example. So typically, wrap-up insurance will start upon substantial completion of the project, and it will run for a certain amount of years following that completion. So you might have a leaky condo case, and they don't discover the water ingress for 10 years from construction. So the wrap-up insurance provider will say, okay, we're coming in and we will contribute towards the settlement of the case. And they'll look at the time on risk and how much time they spent, their policy. So if their policy was good for 5 years, they said they had 5 years on risk of a 10 years of damage. And then they will contribute towards a loss, but they won't cover all of it. There's other parts of that which is beyond the scope of this presentation. Obviously, you have your commercial vehicle insurance, aircraft, equipment, automotive. That's pretty straightforward. Any questions on insurance before I go to bonding? Since I haven't heard anything, Tom, I'll just keep going and we'll save questions.
Sorry, David, it's Tom Elliott here again. I'm just a little slow on the draw. Yes, there is a question, and I'm going to read it to you because it's about 10 lines long, and you'll be able to, I'm sure, decipher it. So just bear with me as I pull it up on my screen. Here is the question. It's actually 2 or 3 questions. How, and I'm going to read word for word. How do you get to a trial decision that separates the damages and in negligence and resultant damage when you are only suing one defendant and it is unclear what portion the insurer has to pay for? Then in parentheses, the question goes on, because it isn't always possible to separate the cost of one from the cost of the other if you send in trades to both replace the windows and fix the damage to the wall system. That's the question.
Well, so you're talking more about the indemnification requirements, and that's a good point in the sense that when you're pleading this, you will be suing both in contract against the party, and you will be suing in negligence and eliciting the insurance through resultant damage. So first the insurer will defend it, and then if there's a decision, there will be an indemnification portion, and then there could be a dispute between the insurer and the insured as to what portion of the indemnity do they have to pay. And so that could be a separate dispute. Of course, frankly, I haven't dealt specifically with one of those disputes. So I'm not sure if the insurance company would have to pay the plaintiff first and then fight over recovery or not. But at the end of the day, the insurer will not be required to provide any indemnification necessarily. Like if there was found there was no resultant damage, it was all workmanship, there could be no indemnification at all. But there's always going to be, well, there's not always, but there could be a dispute between the insurer and the insured as to how much of the indemnification they ought to pay. And so I don't think it would be, in my view, too difficult to have either through the facts of the case or through expert evidence, how to distinguish what the costs were to replace the windows versus what the costs were to repair all the interior of the but sometimes there is an overlap a little bit, and to the extent there is an overlap, I would say, in my view, I know that there are overlaps, and I'm trying to think of an example, but in my view, to the extent that there's any resultant damage that was being repaired and there was still something being replaced, the insurer will, I think the balance would weigh towards the insurer indemnifying for those costs. All right. Did I answer the question?
Yes, but here's another question, and I'll read it word for word. When does risk transfer to the owner?
When, well, I mean, in what, sorry, maybe I can ask for that question to be elaborated on. In what context are you talking about there? Are you talking about in insurance or
So what I'll do, perhaps the questioner can reframe the question, and she says the context is insurance liability.
Well, if you're talking about insurance liability, I mean, there's so many different ways that there could be risk on the owner. If you didn't have insurance, if one of the parties didn't have insurance, that would be a risk where the owner takes the risk. There could be a limitation of the amount of their insurance that they have. There's all the normal litigation risks that you have. For example, if you were what we call contributory negligent, if the plaintiff was partially responsible for the loss due to lack of maintenance, for example, that would be a risk on them. So those are the types of things where the risk will go back to the owner. But there's a multitude of ways that it could. I mean, you're not going to be at risk for making a claim on the insurance policy that I can see. But did I answer the question there, Tom?
As the question is written, I would say yes, but I do invite the questioner to ask a further question or reframe it if the answer isn't what they expected, and the questioner is saying yes. Thank you very much, David.
Okay, thank you. Okay, well, let's move on to construction bonding. This is something it's an area I really enjoy. And I think people don't pay enough attention to certain components, and I'll get into that. So a bond is where you have a surety, usually an insurance company, who provide a guarantee. As we saw before, it's a collateral agreement where they promise that if the principal, one of the trades or the general contractor, doesn't do what the bond says it will do, they will come in and either pay some money or take on that responsibility. So it's a way, bonding is, again, an allocation of risk mechanism. And there's a multitude of different types of bonds. The four most common bonds I deal with in the construction context are bid bonds, performance bonds, labor and material bonds, and lien bonds. So a bid bond, unless you're really into construction, you probably won't see this as much, but they are very important. It's beyond the scope of this to go into the law of tendering. It's a whole very interesting topic within construction. But if you have the principle of tendering is if you have a closed tendering system, and a lot of in the Yukon, a lot of their institutional work requires this to be done through this tendering process. They put out the specifications, they put out a tender package. All sorts of different people, if they qualify, can bid on it. You might have 5 different people bidding, and they have the obligation to take the best bid, and that's typically the lowest price. Sometimes what happens is the lowest price had made a mistake, and their price is too low, and they just simply cannot complete the project in accordance with the price. And not to get into all of the nuances of the law of tendering, but unless it's a palpable error that could have been seen on the surface, and it wasn't sort of an internal error of calculation, the tenderer has to accept that lowest bid. And that's in order to keep the integrity of the bidding process and to make it fair. So sometimes if someone says, well, screw it, I'm not going to do it, I don't like my price anymore, or I've got more work, you have, when they submit their bid, they also have to submit a bid bond. So if that party says, I'm not going to proceed with the work, then the owner can then go to the bid bond and say, okay, you have to pay me the money. And the bid bond is typically 50% of the bid price is what the requirement is. So there's some protection to the owner to ensure the integrity of the system. And it also keeps bidders honest. They don't just put in a low price to see what happens. There's some meat in the game if they can't comply. A bonding is a performance bond is where the bonding company guarantees the performance of a contract. So if I'm a general contractor and I go bankrupt halfway through, you can rely on a performance. The owner can say, okay, bonding company, this guy's bankrupt. You got to come in and finish this project. So they will do that. Sometimes it's not in a bankruptcy context, but 90% of the time, there's some financial difficulties with the party, and that's why the performance bond is called upon. The bonding company then comes in, takes over the general, well, they have different options. They can pay it out, they can bid it out to a new contractor, or they can take it over themselves. But the fact is that and I know at least one person is in the insolvency world in this in the audience. This is where you get into fights sometimes with trustee lawyers, because the bonding company has a right to take all of the funds on that project and control them within certain requirements, of course. In my view, takes precedent to the trustee and controls those funds, because they are entitled to take the remaining contract funds, even if they're unpaid, but for work performed, and use those funds to help complete the project. So technically, generally, it protects against bankruptcy in most cases. Labor and material bond is something I want you guys to pay attention to. Most out of all these bonds, it's something that I'm surprised at how overlooked it is. So a labor bond is where a bonding company, if you don't get paid on a project and you can prove that you were owed the money, the labor material bond, the surety will pay you for that. So a lot of our cases is our clients that come to you and say, well, I need to get paid, I haven't been paid. And if it's any kind of sort of government or institutional work, there's a good chance that there's bonding behind this, right? And I'm surprised at how many times lawyers don't even ask if there's a bond. You can have complete protection against your entire claim. They don't even bother to ask. And the fact is that there is case law. I don't think I've got to there yet. Valera, there's a Supreme Court of Canada decision that says if a party asks whether or not there is a bond and they don't give it to you, they can be personally liable for that loss. They have to disclose the existence of a bond. So when a client comes in and it's anything that's remotely institutional, it's not just like a commercial project, the first thing I do is I ask if there's a bond. And then you make a claim on the bond. I mean, it's not always a straightforward process. You don't just give your invoices and you get paid. They often look at your invoices. Often the principal who owes the money will say, well, we have all these back charges, so you can't pay until we resolve these disputes we have, and it drags out a bit. But there are time limits under that labor and material bond that you have to do certain things. Often it's 1 year from substantial completion that you have to file a claim. And so it's important to get that process started right away, so that even if you're working through whether or not you're going to get paid, you have to have that put together and be ready to start the claim. And I'll say it again, I'm just surprised how few people even think about whether there is a labor and material bond on a project. The next is a lien bond. So this is, I deal with a lot. It's not rocket science. So you have a lien on the project. You may be a general contractor and you may have a progress claim that's $1 million that's owed this month. And the project is being financed, so the banking won't release funding to the owner until the title is clear. So the financing company will check the title, they'll see a lien on the project, and they say, okay, well, we're not going to pay. So then you got to rush around, you got to get the lien removed. And you might have a $20,000 lien from a sub trade, and you're the general contractor, and it's holding up $1 million progress claim. So you can take steps, and there's different legislation in the Yukon, but you can do this to post security, to remove the lien, or you can do it through a trust agreement with the lien claimant. And the lien bond is, you can either do it through cash or through a lien bond. The lien bond is just a promise to pay the value of the bond, the claim of lien. So basically replaces the security in land with a security in the lien bond. So they're valuable tools to use when needed.
David, there's another question for you right up this alley, and it's a rather cryptic question, but it's on bond obligations. And here's the question: Burrard versus Burrard, a decision from Yukon courts on disclosure of bond obligation. Can you comment on that?
This one that I refer to here?
Well, I think so. It simply provides the case reference. Burrard versus Burrard.
Yeah, so that decision, I have to go back to recall specifically what the facts were. But what happened was there was a trade who had not been paid. And the problem, just to step back for a second, the problem that you have is you get a call from your client and you need to get a copy of the labor and material bond to make a claim on it. And the labor and material bond isn't given to all the parties, right? So there might be key trades that have, or subcontractors that have labor L&M bonds, we call them, or that could be the general contractor, but they're holding it, or the owner's holding them. So you may not have them. You may not even know if they exist. So you have to find a way to get those. So in this case, Valera had written, I can't remember was the owner or Bird Construction, and said, can you provide us a copy of a lien bond, a labor and material bond? And they failed. They just ignored them, didn't provide it. They ran out of time, if I recall, to file, and then they sued the party who didn't provide it. And the Supreme Court of Canada says that the bond is an essential component of the project and of the risk allocation, and you have a duty to disclose that when requested. And the duty actually may go beyond whether it's requested or not. If they're aware that there's an issue, you have to there's a purpose for the labor and material bond, and that's so people can get paid when they're not being paid. And if that information isn't disclosed, then there's liability. So that was the nature of the decision. It's been some time since I've read it, so I don't recall all the specific facts of it, but that's the decision there.
Okay, David, well, two things there for your audience. Let me say that we are now about 6 or 7 minutes away from the end of this program. And to you specifically, David, here's another question. And the question is this, I'll read it. Curious what your thoughts are on Yukon's bid value reduction process as it relates to best efforts to use Yukon First Nation companies and Yukon First Nation hiring priorities. That's the question.
Well, that's what my thoughts are? I mean, that is, well, my thoughts are you should attend the conference that we're giving in October, where I'm talking a lot about First Nations involvement in construction. So it's very clear that all across Canada and on all levels of government, that the involvement of First Nations in a variety of different ways is very important, but it's really becoming important in construction. So, and I'm aware that the Yukon government has come up with this thing where so when we have a tendering process, what we talked about before, lowest price isn't the only factor that they'll look at. They're allowed to look at other factors as long as they're being objective. And what they've said is, and they have identified the specific First Nations that they consider to be eligible. And they say, well, it's kind of like a point system. So if you involve those First Nations, you get more points, and you have a better chance of obtaining the bid. And there's other components to that legislation as well, where they really like they just encouraging the use of First Nations. It can be even it's been a little while. I had to deal with that particular I don't know if it's legislation or not, but I had to deal with that specifically. And I recall that even if you have a partnership, that will suffice. So my opinion, like politically, I don't have an opinion. I think it's important to involve First Nations, and it's a reality in construction. That particular legislation, some of the issues are, there might I knew one guy who lived in the Yukon all of his life, but he was status from one of the First Nations from northern BC, and felt that he should be, also get points as well. So there are some challenges with that as well. I'm not sure if I'm answering your question, but my thinking is that whether it's very important, I think it works, and I think it's important to involve them. And you're seeing that throughout all of construction anyways, in a variety of different ways. And there's going to be a lot of work in that in terms of whether you're a solicitor doing joint venture type agreements with the First Nations. I see a lot of that. There's no big project that doesn't have a First Nation component these days. So I think the Yukon government is doing the right thing, because that's what everyone's doing. Does that answer the question? Or is there something specific about that legislation you wanted me to comment on?
I think, David, that most certainly answers the question in chief. And because of time constraints, I think we'll have to leave it there. So thank you for taking an initial crack at your thoughts on that. And we're just a few minutes away from the end of the program, and because this topic is so interesting and so wide in scope, and there's still questions coming in. David, is there a way that people can follow up with you after this webinar?
Sure. Sure. I mean, you can always email me. And I can do my best to get back to you for sure, without any doubt.
Okay. And if you don't have David's email address, let me just say that you can contact the Law Society for it. But David, if you're okay, I can just read it out right now, if that's okay.
Sure, of course,
with you.
Yeah.
Okay, so it's D Plunkett at Burrard Law, all one word, .com. So fire your questions away to David that you may have, because as I mentioned, they're still coming in. And at this point in the presentation, I'd like to thank a number of people. First and foremost, of course, David, I'd like to thank you, and we wish you well in your upcoming presentation that you're doing at a national Canadian Bar Association event on October 13th and 14th, where I understand you're going to be presenting on First Nations First Nation and construction contracts. So look out for that, folks. If you want to follow that, I'm sure it's on the Bar Association website. I'd also like to thank the Law Society's PD committee for putting this together, the Law Society administrative staff for their technical support. I'd like to thank the participants and for all of you who have joined in from far and away and near and close. And of course, if you have any questions about this presentation or any future one, just have a look at the Law Society's event page, which is on their website, or do it the old-fashioned way, walk into their office at 104 Elliott Street, Suite 304 in Whitehorse. Thank you, David, and thank you for all who have tuned in today. Take care.